What is copyright? Copyright is a form of protection grounded in the U.S. Constitution and granted by law for original works of authorship fixed in a tangible medium of expression. Copyright covers both published and unpublished works. Under U.S. copyright law, the author of a creative work owns any copyrights associated with it. In an employment situation, when an employee creates works in the scope of their employment, the employer becomes the owner of the work and any associated copyrights to those works. Many businesses use independent contractors for projects or parts of a project where hiring a full-time employee is simply not feasible. Once the job is done, there is no more need for the contractor. It is important to note that instructional designers working independently are the sole owners of their creative work. Pictures, designs, multimedia, images, and other works protected under copyright do not transfer automatically to the client of the contracted professional. Caution: if an agreement is not made with an independent contractor to transfer ownership of what is created to the client, the contractor is the owner of all copyrights associated with works created for that client. For example, if Bob contracts Jill to create a website for his company without a written agreement to copyright of the created work, Jill will have sole ownership of the copyright to the website. Bob will be able to use the website for its intended use, but he won't be able to use any part of the website for anything else without seeking permission from Jill. An oral agreement or understanding is not sufficient to secure copyright of created works. It must be in writing and explicit as to the transfer of copyrights, not just rights. Before any work commences with a contractor, it is important to put an agreement in place that all creative works will be assigned to the hiring party. Remember, creative works produced by employees for an employer are implicitly owned by the employer unless an agreement was made beforehand. If a person hires a contractor and does not make an agreement beforehand to transfer ownership of copyrights to the hiring agency, the author remains the contractor and the hiring agency will have limited use of the works they paid someone to create for them. Before a contractor's work begins, create a contract that assigns all created works to the hiring agency, the owner. It must be in writing to be valid. An oral agreement is not necessary, and the agreement must be explicitly stated as to the transfer of copyrights, not simply rights.